Hey, everybody. Welcome back to the Court of Random Opinion. My name is Neidigh. We had another filing come through while I was reading the judgment on the protective order. I just had a couple things in my work queue I had to finish before I could go through this one with you guys. It's going to be a short one. There's only about 10 pages to read. And it's Leslie Sloane and Vision PR. They had made a motion to dismiss Justin Baldoni's complaint. Justin Baldoni's side had come back with an opposition to that. And then now Sloane and Vision PR get to respond to that. So this is pretty standard, but we're going to go through it together. Like I said, we'll run through it really quick. I don't have a ton of time before I have to get back to work again. So give me just a second, guys. Right. Okay. Leslie Sloane and her company, Vision PR, have suffered significant distress and economic loss from being dragged into this litigation. It is without question that the Wayfarer parties engaged in a smear campaign to, in their own words, bury Miss Lively and destroy her life. Rather than take responsibility for their egregious actions, they have peddled a false story about Miss Sloane, but there was never a factual basis for their invented storyline, as evidenced by the amended complaint's dearth of specific allegations against the Sloane parties. Ms. Sloane did not write or otherwise contribute to the New York Times article, the only article alleged to be defamatory and the supposed genesis of this entire action. And the few statements she allegedly made to one Daily Mail reporter are nowhere close to defamatory. The Wayfarer parties, having apparently reached the obvious conclusion that the operative complaint is indefensible and that the Sloane parties' motion to dismiss should be granted, repeatedly request another chance to amend, rather than defend their pleading as written. The Wayfarer parties fail to attach a proposed amended pleading, however, and instead vaguely assert that they have obtained additional information and expect the court to take their word for it. But no amendment or additional information could cure the defects in the amended complaint. This footnote here says the Wayfarer party's 43-page opposition brief violates Individual Rule 2.1, which sets a 25-page limit, absent agreement of the parties. The court should disregard the Wayfarer party's overlength arguments. Interesting. I had no idea about that. If true, then that sucks. All right. 1. The amended complaint must be dismissed due to group pleading. The AC amended complaint should be dismissed because it is rife with impermissible group pleading. The AC lacks a basic mapping of which plaintiffs are asserting which claims against which defendants and for what. That is chaotic. For example, the AC nonsensically asserts claims of extortion against the Sloane parties despite failing to identify any communication where they made a request of any kind to any Wayfarer party. Similarly, all 7 Wayfarer parties assert defamation claims against the Sloane parties, even though Ms. Sloane is not alleged to have made a single statement, let alone a defamatory statement, regarding 6 of the 7 Wayfarer parties. Such collective pleading is impermissible. The group pleading defect cannot be cured with new conclusory allegations of conspiracy. The Wayfarer parties concede as much, admitting they intend to move for leave to amend to fix the group pleading issues. But they have already been given 2 opportunities to submit an actionable complaint and have failed both times. The amended complaint fails to state a claim for civil extortion. This is number 2. Hold on. First, let's get to the footnote there. It says the Wayfarer party's assertion that California law should apply because they suffered injury there contradicts the AC, which instead specifically alleges that injury was suffered within New York. In fact, the Wayfarer parties concede that the genesis of this entire action is a New York Times article that indisputably emanated from New York by a New York media defendant. This concession is fatal to their choice of law argument. Okay, now getting into number 2. New York does not recognize a claim for civil extortion, and the court should dismiss this on this basis alone. But even if the court were to apply California law and follow the handful of California courts that have recognized a claim for civil extortion, the claim would still fail, because the Wayfarer parties fail to allege the most basic element, that the Sloane parties obtained anything from the Wayfarer parties. Okay. The extortion claim is also impermissibly duplicative of the defamation claim. If it were true, as Wayfarer argues, that a defamatory statement was alone sufficient to give rise to an extortion claim, Plaintiffs could avoid the structures of defamation law by artfully pleading defamation claims as alternative torts. That is not the law. Further, the Wayfarer parties do not even attempt to address the various other bases for dismissal, including that 1, the AC fails to allege the Sloane parties used force or threats to try to obtain anything from them, and in fact does not even allege Ms. Sloane spoke to 6 of the 7 Wayfarer parties. 2, the Sloane parties cannot be held liable for allegedly extortionate actions taken by another person, and 3, the AC does not plead extortion with particularity. All right. Can you just read that, or do I need to zoom in more? Just let me know. All right. 3, the amended complaint fails to state a claim for defamation. Okay. A, Ms. Sloane's statements do not concern 6 of the 7 Wayfarer parties. The Wayfarer parties concede that both New York and California law require an allegedly defamatory statement to be of and concerning the plaintiff, yet they fail to point to any specific statement by the Sloane parties concerning 6 of the 7 Wayfarer parties. While the Wayfarer parties suggest that the Sloane parties made some unidentified statements to the effect that the 7 Wayfarer parties engaged in sexually inappropriate conduct towards Lively and or retaliated against her, they do not and cannot specify what those statements are. Such vague arguments are unsupported by the AC and are insufficiently specific to state a claim for defamation. The Wayfarer parties also cannot rely on the small group exception to the group libel doctrine. Unlike in the cases recognizing that exception, none of Ms. Sloane's alleged statements describes a particular, specifically defined group, such that the doctrine could conceivably apply. Instead, her alleged statements refer to Baldoni individually. The Wayfarer parties' defamation claims, other than Baldoni's, must be dismissed on this ground alone. B, Ms. Sloane's statements are an actionable opinion or are substantially true. Okay. Let me see if these footnotes are something we should read. Okay. So we have down here, it says, contrary to Wayfarer parties' arguments, whether a statement is one of fact or opinion is a question of law for the courts. Okay. As the Wayfarer parties acknowledge, statements of opinion are inactionable under both New York and California law. The Wayfarer parties offer no support for their assertion that the statements, the whole cast doesn't like Justin, and the whole cast hates him, are statements of fact. Nor could they, since it is well settled under both New York and California law that such expressions of one's view of another reflect an actionable opinion. Okay. Given the statement's context, the phrase, "and now she's saying that Blake was sexually assaulted," reflects the speaker's subjective assessment of Miss Lively's publicly accessible CRD complaint, rendering it a statement of opinion. So the problem with that, guys, is the CRD complaint, that was not like a publicly accessible thing until after it was blasted everywhere. So, like, I don't know if that makes a difference or not. We'll have to ask an attorney. But okay. In attempting to argue otherwise, the Wayfarer parties cite only one case, which they misrepresent. Contrary to the Wayfarer party's opposition brief, Buckley did not involve a sexual assault accusation at all, and instead held that the terms fascist and radical right are too debatable, loose, and varying to be susceptible, oh my gosh, I can't speak, to proof of truth or falsity, which only supports the Sloane party's position. The Wayfarer parties also suggest, for the first time and with no support, that Ms. Sloane called Baldoni a predator. The AC fails to allege this statement or attribute it to Ms. Sloane, even with a modicum of specificity. In any event, words like predator are a textbook example of vague, imprecise statements of hyperbole, considered non-actionable opinion. In the alternative, to the extent the court finds that any of Ms. Sloane's alleged statements are statements of fact, those facts are substantially true. So they're citing allegations from the Wayfarer parties concerning Baldoni being ousted, shunned, and iced out, as well as Baldoni's innocuous improvisation during filming that Lively has since alleged was harassment. The Wayfarer parties do not dispute the truth of any of these specific allegations and instead argue that substantial truth is a question for the jury. But under both California and New York law, defamation claims are properly dismissed at the pleading stage where, as here, falsity is not adequately alleged in the complaint. C, the sexual assault allegations are inadequately pleaded. The Wayfarer party's claim for defamation, to the extent based on paragraph 193's allegations concerning sexual assault, should be dismissed for the additional reason that is inadequately pleaded, since the AC provides only an image of words that were allegedly used by a reporter and does not allege what words Ms. Sloane used, if any, when she said to them, to whom, or in what context. The Wayfarer parties argue that the heightened pleading requirements does not apply, but even under Rule 8's more lenient standard, the Wayfarer parties' allegations are deficient. The Wayfarer parties also argue for the first time, and with no support, that on information and belief, Ms. Sloane made some unidentified additional statements to the press, but it is well settled that defamation must be pled with specificity and not on information and belief. The Wayfarer parties, this is D, Wayfarer parties failed to allege actual malice. The Wayfarer parties failed to identify any allegations in the AC sufficient to meet the rigorous actual malice standard under New York or California law. The opposition asserts that Ms. Sloane knew her statement that the issues on set had nothing to do with Blake was false, because if Sloane believed that Baldoni had sexually assaulted Lively, that obviously would not be the case. But by the AC's own allegations, the nothing to do with Blake statement was made on August 8th, 2024, well before the sexual assault statement was made, following the release of Lively's administrative complaint on December 20th, 2024. There are therefore no allegations in the AC alleging that Ms. Sloane subjectively believed that any alleged statement was false at the time it was made. Similarly, the Wayfarer parties argue that the Sloane parties knew that Baldoni had not sexually assaulted Lively because Lively herself did not allege that Baldoni sexually assaulted her. Okay. This argument fails because Ms. Lively's public allegations of unconsented touching and kissing fall within New York's definition of sexual assault. Because Ms. Sloane was entitled to credit Ms. Lively's allegation, the Wayfarer parties cannot show that Ms. Sloane ever acted with actual malice. And here the footnote, it says, as Ms. Lively's amended complaint explains, Ms. Sloane was not informed of the details of her sexual harassment when she spoke with the Daily Mail on August 8th. E, the Wayfarer parties fail to allege special damages. The Wayfarer parties do not dispute that they fail to allege special damages, and instead argue that Ms. Sloane's statements are defamatory per se. Ms. Sloane's alleged statements that the whole cast doesn't like Justin and the whole cast hates him do not qualify, however, since they convey only a general reflection upon Baldoni's character or qualities. Likewise, the statement, and now she's saying that Blake was sexually assaulted, is insufficiently precise to qualify as defamatory per se. The Wayfarer parties identify no authority concerning similar statements holding to the contrary. Okay. F, the Wayfarer parties' new conspiracy to defame arguments fail. In a last-ditch effort to save their defamation claim, the Wayfarer parties assert their theory of liability as one where each of the consolidated defendants are co-conspirators who engage in the alleged campaign of defamation collectively. New York and California do not recognize conspiracy as a standalone tort, however, and there can be no conspiracy to make a defamatory statement if the underlying statement is held not to be defamatory in the first place. Even if the court were to allow defamation claims to proceed that were made by other parties, the Sloane party should be dismissed as to those statements because the AC fails to allege any specific agreement among the Sloane parties and their alleged co-conspirators, let alone explain when the Sloane parties entered such agreement or what overt act they took in furtherance of it. Isabel, there's a page called Ex-Patriarch saying Justin's lawsuit has doctored text. I don't know. Like I said, I've been really busy today, guys. I got a lot of stuff to do. So I did see your message on Instagram. I don't have too much time to look into this stuff right now, so I'm gonna have to wait till the weekend. But thank you. I did see your messages. I appreciate it. The AEO was covered in the last live stream. Yeah. That was the protective order judgment. This is something else. This is regarding the motion to dismiss Justin Baldoni's complaint by Leslie Sloane and Vision PR, who are Blake Lively's publicists. All right, let's get through the rest of this, guys. The footnote here says, the Wayfarer party's remaining arguments concerning Malice are meritless. They argue that any statement accusing them of a smear campaign was made with actual malice, but there are no allegations that the Sloane parties ever made statements to that effect. The Wayfarer parties also argue that the 6 Wayfarer parties other than Baldoni are not public figures. This is irrelevant because the AC does not allege the Sloane parties made any statements concerning them. Okay. The Wayfarer parties concede as much, arguing they cannot articulate the conspiracy absent discovery. But Rule 8 does not unlock the doors of discovery for a plaintiff armed with nothing more than conclusions. Plaintiff has failed to plead a proper conspiracy claim, and they're quoting another case, under Federal Rules of Civil Procedure 8, and cannot engage in discovery to cure the defects in the complaint. Okay. 4, the false light claim fails. The Wayfarer party's false light claim also fails. It is undisputed that New York does not recognize a claim for false light, and even if California law were to apply, the false light claim is based on the same facts as the defamation claim and is therefore superfluous and should be dismissed. The Wayfarer parties make no effort to argue that their defamation and false light claims are factually distinct. They also make no attempt to refute that they fail to satisfy the highly offensive element of a false light claim, and they concede that if the defamation claim fails, it does. The false light claim fails with it. The false light claim should thus be dismissed. There's another footnote here, guys, that says the extent the conspiracy claim is based on the New York Times article, it also fails because the article is privileged under New York Civil Rights Law 74, Section 74. The Wayfarer parties argue that 74 is inapplicable to the Sloane parties since they are not members of the press, but it is well settled that the provision applies equally to non-media defendants. All right, here's point number 5. Ms. Sloane and Vision PR are entitled to attorney's fees and costs. Upon dismissal of the AC, the court should award fees and costs under New York's anti-SLAPP law. Contrary to the Wayfarer party's arguments, the Sloane parties respectfully submit that Rule 11 is not sufficiently broad to conflict with the anti-SLAPP law. Okay. Including because the anti-SLAPP law does not merely operate to discourage frivolous claims, but instead protects a particular class of defendants and thus vindicates substantive interests of the state not covered by Rule 11. Indeed, federal courts routinely grant fee awards under state statutes and do not find that those statutes conflict with Rule 11 or other federal rules. Okay. For the foregoing reasons, Leslie Sloane and Vision PR respectfully request the court dismiss the claims against them with prejudice, award them their attorney's fees and costs under New York anti-SLAPP law, and strike Exhibit A to the amended complaint. We got a couple of footnotes here. Okay, multiple courts have held that New York's anti-SLAPP law fee provision applies in federal courts. The next one says, the Wayfarer parties repeatedly request leave to amend, but a bare request to amend a pleading contained in a brief which does not also attach the proposed amended pleading is improper under Rule 15. I wonder if there's anything I can do about that. And the last one says, the court should strike Exhibit A, which was the evidence timeline in Justin Baldoni's amended complaint. Should strike Exhibit A pursuant to Rule 12F. The Wayfarer parties concede as much by failing to address the Sloane party's authorities and admitting they would draft a second amended complaint differently. All right. So that one wasn't, too bad. It was pretty short. So the judge will have to rule on that, whether or not the complaint against Leslie Sloane and Vision PR gets dismissed. Now, remember, the New York Times also filed a motion to dismiss, which Justin Baldoni came back and opposed recently. I'm not sure. I can't recall now if the Times did their response to that. Let me check. I don't think so. I'm just looking at the docket really quick. I don't think so, but if they did, then it's floating out there somewhere. All right. Okay, guys, I got to get back to work again. I appreciate you being here. Thanks for watching. Thanks for the support. Please hit the like on this video, and I will see you guys soon. Bye.